This is a guide to getting a divorce or a legal separation with no children in the state of Colorado. First, you'll need to decide how you're going to file. If you'll be filing on your own and without the assistance of the other party, then you'll need to complete the case information sheet, the petition, and the summons. Complete all documents signed and notarized. Then the documents will need to be served on opposing party. Then documents may be filed with the court. If you'll be filing jointly, then you'll only need to complete the case information sheet and the petition. You will not need to complete the summons. Both parties should sign and execute and notarize the case information sheet and the petition. These documents may then be filed directly with the district court. Either party must reside in Colorado for at least 91 days prior to filing the documents in the district court. This is how Colorado retains jurisdiction. You will file in the county where you or your spouse reside. That is the proper county for your filing. The court will review the documents and they will set what is called an initial status conference. The initial status conference is typically set on or around 42 days after filing the documentation. For service issues, if you'll be filing on your own, you will need to hire or find a disinterested person who is at least 18 years or older and must serve copies of all documents on the other party. Proof of the service will be required, and the person completing service will need to complete a return of service and file with the court. Once these documents are filed and service is proper, the court will issue what is called a case management order, or a CMO. This CMO details the process that is ahead in the district court. A sworn financial statement is required from both parties. This sets forth the incomes, the assets, and the debts of both parties. Full disclosure is required by all district courts. The certificate of compliance is and dedicates the supporting documentation of the sworn financial statement. All supporting documentation must be mailed to opposing party and delivered in the certificate of compliance. The separation agreement, the affidavit for decree without appearance of the parties, and the decree are typically only filed if all issues are resolved between the parties. The pretrial statement, however, may be filed by each party if attending a trial or the issues are not resolved. At the initial status conference, you may be required to attend if you cannot complete all the documents above. If there are any outstanding issues, then you will need to attend the status conference. If you and the other party agree on all issues, however, the court may simply issue the decree on or after the 92nd day from filing your initial documentation. If you and the other party do not agree on all issues, then you may be required to attend mediation or contest a hearing. This may be set at your initial status conference. The decree may be entered at the conclusion of your hearing once all issues have been resolved.